Well, hello everyone, and welcome back to AJ507 Ethics in Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week's chapter is going to cover Chapter 6, and we're going to talk quite a bit about police discretion and dilemmas. So, a lot of information to cover. This is easily going to be a two-part lecture because we just have so much content, but let's go ahead and kind of jump right in because we have a lot of things to cover. So a couple of the learning objectives: we want to take a look at evidence that law enforcement officers perform their role in a discretionary manner, present information concerning the prevalence of factors that might be associated with the use of force by police, take a look at some of the predictors associated with use of excessive force, talk about some ethical issues involved in proactive policing or proactive investigations, and discuss the ethical issues involved in reactive investigations. So again, a lot to cover, so here we go. So in this particular chapter that we're going to go through, we really want to focus on how police utilize their discretion. Now, recall that discretion is the power to make a choice, a choice of action, if you will, from several alternatives, or at least two things, okay? And consider that even the youngest or the newest police officer has an awesome power over the citizens that he or she may serve, right? Now, while most police officers are respectful of, those they encounter and abide by the law, if they do not, there is little immediate recourse. Okay? There's a recourse, but not necessarily immediate. If you refuse to, let's say, resist, you may be subject to physical force to be taken into custody. And if a police officer insists that you stop your car, you are supposed to do that. If they ask to search your car, you could say no, but then they could make you wait a reasonable amount of time for a drug sniffing dog, or even arrest you for something different and then search your car subsequent to an arrest. So even if an officer insists that you sit on the curb, you are really supposed to. And there's a reason that officers do that. It's really is for officer safety. It's not to make people look bad. And of course, in certain times, if that officer insists that you leave a certain area because of activity or an investigation, you are supposed to do that. So, those officers who conduct unconstitutional searches may be punished later, and victims may receive large settlements paid by the taxpayers, not by the offending officers. However, the fact remains that at that moment, that individual's that officer really is in control of that particular situation. So, with that being said, most ethical dilemmas that police officers face derive from their powers. Okay, and their powers of discretion. Now, Muir in 1977 describes moral dilemmas of the police officer as frequent and unavoidable. And you got to kind of think about that, because as you contact so many different individuals, there is going to be a level of frequency and, unavoidability, if you will. So, again, moral dilemmas of the police officer as frequent and unavoidable, always unpopular with some groups, usually resolved quickly, dealt with alone, and really involving a complex criteria. Okay? So, police officers are trained in the law, and they know department policy, but that still leaves a wide range of possible alternatives, right? When they arrive at a scene, or when they see something. Should they pull a driver over who forgot to signal? Should they stop a person walking in the street in a group that might look suspicious? These are all discretionary type situations, and they're very complex. Okay, so they're not as simple as they actually seem. Now, when we talk about discretion and discrimination, when individuals have discretion, individual prejudices and perceptions of groups such as women, minorities, and sexual preference can influence their decision making. And, officers' views of the world really do affect the way that they do their job. If these views include prejudicial attitudes towards groups, etc., and such prejudices affect decisions, then those particular groups, whoever they are, may not receive the same protections as those that the officer deems as good citizens, right? So, and that could be anybody, all right? It doesn't necessarily have to be a minority group. It could be your attitude as who you are can influence who you believe might be kind of a good group or bad group or whatever you want to call it. Now, it is also true that we are all subject to what we call implicit bias, which is a subconscious bias that we may not even be aware of, but that may really impact or affect our decision making. And I put a link to the Harvard University implicit bias quiz or exercise, if you will. And you can go there and you can take it and they'll email you the results and nobody else can see it, but it's kind of an interesting thing. And you may want to do that. I think it would be actually cool for everybody to do it. And you don't have to share the outcome, but just kind of know, kind of what you're thinking, or, maybe you didn't know that that's the way you think, etc. Okay. The point is that that police officers are more, not that police officers are more prejudicial than the rest of us. It is their special position that creates the possibility that their prejudices could cause a citizen to be treated differently. Okay? And it's more of a problem when any organization or agency, if you will, kind of has that occupational culture that reinforces some type of prejudicial view. So again, we're not just talking about the individual, we're also talking about the agency itself as well. So, essentially, when police act on prejudice while performing their jobs, discrimination then takes the form of enforcing the law differently or withholding the protections and benefits of the law. So, that's really, again, very important for us to understand, because we're supposed to have this balance, but sometimes it doesn't always turn out that way, right? And we've seen, law enforcement officers that do a great job, and we've seen some that don't and shouldn't be there, and we've talked about that before. But okay, so just kind of finishing up with the discretion and discrimination portion. So by definition, discrimination occurs when a discretionary decision maker treats a group or individual different from others for no justifiable reason. And that would include sexual orientation, race, national origin, social status, etc. So if you pulled these, either one of these two individuals over on a traffic stop, one after the other, and it doesn't matter in what order, would you treat them the same? Does that kind of make sense? And you can be honest with yourself in your own mind and think about, would you in fact treat them the same, because you are supposed to. Okay, so a couple of forms of discrimination. Again, we talked about enforcing the law differently, withholding the protection of law, but this would include things like greater disrespect, greater use of force, racial profiling that we'll talk about in a little bit, and what we call a greater use of pretext stops. And we'll talk a little bit more in the chapter as it relates to this thing called pretext stops. So now let's take a look at the racial divide, if you will. So the system of law and punishment, the courts that administer the laws, and the correction systems that make decisions regarding the liberties of those convicted have all been described as agencies that have in the past had a tendency, okay, they use the word pervasively, which means tendency, to discriminate against minority groups. Now, the police in this view, meaning if you think this way, and not everybody does, but we're just kind of having a conversation, are just one element of that big criminal justice umbrella, right? And we've already kind of learned that. Now, most studies indicate that blacks express more distrust of the police than whites or Hispanics. And in one of the latest Pew Research Center surveys, and these are actually really good surveys to kind of look at different things, and I took a kind of a snapshot of part of the 2016 or the 2016 survey research, public opinion report. There really were some dramatic differences between whites and blacks, as it relates to police performance. And you can kind of see we're talking about the perception of protecting people from crime, using the right amount of force, treating racial and ethnic groups, equally, holding officers accountable. And you can see that there is a very large gap, right? So it really is important for us to kind of understand, why is there such a gap? And then we need to figure out what we can do to, of course, close that gap. So this study, again, showed differences between police performance relating to protecting people from crime, using the right amount of force for each situation, treating racial and ethnic groups equally, and then holding officers accountable when some type of misconduct occurs. And I put in a couple of other links to some other surveys if you want to take the time to look, because there's just a little bit of a difference between each one of these. You have the divide between black and white on police. You have how white Americans differ in their views on criminal justice. You have black Americans were less confident in the police than whites before the George Floyd death incident, right? And then you have a interesting survey on race and policing in America. So take the time to look at those. Okay, so kind of pushing forward. So studies have shown that civil rights complaints against police correlated positively to the percentage of minorities in the population, that more than twice as many lower class African Americans as whites report disrespectful language or swearing, etc., by law enforcement. Okay, age, income, sex, and education, living in metropolitan areas, and experiences with police all have been kind of showing as influencing attitudes towards law enforcement. And race does remain a key variable even after, controlling for other factors, arguably because blacks report having more negative interactions with police, are more likely to be exposed to negative media portrayals of police misconduct, and are more likely to live in high crime areas where police employ a more aggressive style of law enforcement. So kind of sticking with this, the videos that you see on YouTube show terrible examples of police officers who are rude and abusive. And they have good ones too, but typically it's some of the rude stuff that gets on there that people are kind of drawn to, right? However, many academic studies using observers indicate that residents, both black and white, are initially disrespectful to police 3 times as often as police are initially disrespectful to the resident. So 15% to 5%. So that to me is kind of an interesting thing, right? And factors associated with being disrespectful include heightened emotions, the number of people hanging out or bystanders, the existence of intoxicants, being mentally impaired, and also being in a disadvantaged neighborhood. Now, research also indicates that police officers may not even realize when they are treating black community members insensitivity, nor understand how their actions appear to minority residents. So maybe they're just kind of ingrained with the way that they do things and they're being rude and they don't really know. But a lot of times they do as well. So let's not, we're not going to kind of sugarcoat that, but we're talking about some of the recent research. So that takes us into racial profiling. So racial profiling occurs when a police officer makes a stop based entirely on race or ethnicity. And generally, racial profiling refers to traffic stops based on race, leading to the term driving while black, if you will. And we'll talk a little bit in a moment, but a pretext stop refers to the practice of police officers to use minor traffic violations to stop a person, specifically to look for other evidence of wrongdoing, usually done via a consent search. Okay, does that kind of make sense? And the Supreme Court actually upheld the legality of this stop in a case called Wren versus United States. So let's just kind of keep going though, but that's an interesting case law. Now, in general, minorities are targeted because of a belief that they are more likely to, be a criminal or commit criminal acts. And again, I talked about the pretext stop. This refers to the practice of police using minor traffic violations to stop a vehicle, even though their mindset is to obtain consent to search the car to find evidence of something else. And again, the U.S. Supreme Court has said in Wren versus U.S. back in 1996 that this process is okay in the sense that as long as the officer does have reasonable suspicion, being the traffic violation, it actually occurred, you can stop the car even if your mindset is somewhere else. You can still stop the car for that violation. And then if there's other information that leads you to other evidence, then that evidence will be admissible. But again, they're talking about it, or we're talking a little bit about maybe overusing this pretext stop, right? Simply to stop people so you can get in the car to find something else. So just a little bit more, kind of information. The federal government trains law enforcement agencies to use pretext stops in high crime areas, and they are considered legal. Again, in 1996, a unanimous Supreme Court ruled in Wren versus U.S. that pretext stops are constitutional as long as police officers identify the actual violation of that traffic law, regardless of their subsequent motivation. So kind of going a little bit further and sticking with racial profiling, though, racial profiling actually began when federal agents developed a profile, if you will, of drug smugglers to assist Border Patrol and customs agents at, bus stations, airports, train stations, etc. Okay. And so there were certain characteristics that drug smugglers would have. And that's kind of how the profiling thing started. But, it's kind of, we can obviously see how that could possibly be abused, right? And some of the, indicators of profiling when it comes to airports, et cetera, could be travel patterns and behavior, as well as, race, demographic information, et cetera. And the concept also was expanded to highway drivers by state patrol officers who were attempting to basically stop the flow of drugs up through the interstates of Florida, Georgia, Texas, and some of those other states. Now, observers again contend that what eventually happened is that the behavioral and other things affiliated, with profiling were abandoned, so that decisions to target suspected drug-involved individuals were reduced purely to race. So racial profiling then became known as the practice of officers stopping minorities for minor traffic violations. That kind of makes sense. And then to search the car for drugs or guns or some other type of evidence. Okay, so we've kind of gone through that very, very thorough. So kind of moving on, a Bureau of Justice Statistics study utilizing an addendum to the National Crime Victimization Survey showed that more black drivers than white or Hispanic drivers, 13% to 10%, so not a lot, but it's still more, were pulled over for traffic stops. But interestingly, no difference existed for street stops, meaning pedestrian checks. So more car stops, were basically carried out on black drivers than white or Hispanics, 13% to 10%. But when you talk about stopping someone on the street, there was no difference there. So that's kind of an interesting thing. In other studies, researchers differentiated traffic stops and what they call investigative stops. A distinction made between police stops that occur because the driver commits a clear violation and those where the officer is using the stop for some type of investigative purpose. And then I also put a little screenshot. The U.S. Department of Justice typically publishes these probably every 3 or 4 years on different aspects regarding policing, and this one happens to be police behavior during traffic and street stops. So, when we talk about the law and racial profiling, there are a couple cases that are really important for us to, kind of really know. Okay. First is United States versus Martinez Fuerte. This is 1976, and this legitimized the use of race as a criteria in profiling at the border. Etc. And then, of course, we have the Wren versus United States in 1996, where the U.S. Supreme Court upheld pretext stops. And again, the law allows race to be considered as only one element in deciding to stop an individual. And you can click on here and you can actually go to the case and take a little bit, kind of a broader look at it, if you will. Okay, so before we jump into another controversial type topic, let's finish up really quick with just a little bit more, statistical information. Keep in mind that, again, the investigatory stop is proactive policing for crime, mostly drug control. but it's a cost benefit question as to whether the benefit gained is worth the cost in the, kind of in the apathy, if you will, it takes, it generates among those who are stopped. So is it really worth it, I guess, is one of the questions that we're going to kind of think about as we move into this other subject called stop and frisk. Now, for this chapter, again, because we do have quite a bit, I'm probably going to go over just a little bit over the 30-minute mark, and then we'll go into part 2. But the text of the Fourth Amendment appears to indicate that a search and seizure of an individual must be based on a warrant founded by probable cause. Well, that's not really the case. In 1968, in Terry versus Ohio, the U.S. Supreme Court confronted the issue of whether individuals may be lawfully stopped and frisked, which is kind of a pat-down, right, of the outer clothing for weapons, etc., but it's technically a search, under the Fourth Amendment based on just reasonable suspicion. So that's a really interesting case law, because we all know that you need probable cause to search or arrest, and probable cause in your affidavit in order to get a search warrant. But here, in Terry versus Ohio, the U.S. Supreme Court says, yeah, all that other stuff is true, but with kind of stop and frisk, if you will, in this case, it's okay to do a quick frisk or a pat-down based on reasonable suspicion that an individual is armed, etc. So let's kind of talk about it a little bit more. The practice of stopping, interrogating, and frisking individuals without probable cause had been part of the arsenal of local and state law enforcement officers for many decades. States like New York passed statutes explicitly authorizing the police to, quote, stop any person, unquote, who is reasonably suspected of engaging in or about to engage in criminal activity, and to carry out a search to, quote, protect life or limb, unquote. So it's kind of interesting, right? On whether or not, does that really make sense? And to some it does, and to some it doesn't. And again, Terry versus Ohio was the first case in which the Supreme Court approved a search and seizure of a person in a criminal case under the Fourth Amendment based on reasonable suspicion. And the reasonable suspicion standard was derived from basically balancing the need for swift action by an officer to investigate, detect, or prevent crime against the modest intrusion of a frisk or a pat-down. Okay? So again, that other type of police stop is called a Terry stop, or sometimes they call it an investigative detention. And again, in Terry versus Ohio, the Supreme Court allowed officers to hold someone for a reasonable length of time when they encountered that person on the street and had a reasonable suspicion that there had been or was going to be a crime committed. The officer was also allowed to basically pat down or frisk the person for weapons to ensure the officer's safety. Now, realistically, this has led to a widespread practice of stopping individuals, generally young black males in high crime neighborhoods or in housing developments or housing projects, because of the suspicion that they were involved in drug sales. Now, while police view this as a reasonable approach to crime, and it can be thought that way, those stopped multiple times a week as they go about their business, they really don't look at it that way, right? And that would kind of make sense. What if you were stopped every day and the same thing happened to you, where you're patted down, but really all you're doing is going to school or going here? But on the other hand, isn't your job as a law enforcement officer to focus in on people that are suspicious that might be committing crime? you can see the total dilemma, right? Now, a little bit more, at the height of the stop and frisk in 2011, New York PD officers stopped about 685,000 individuals under some type of investigatory detention. And civil liberties advocates complained bitterly that the stops were discriminatory, since minorities were more likely to be stopped than whites without legal justification. And this conclusion was reached because the officers' stop cards, and they would fill out cards each time they stopped someone, that were supposed to detail that reasonable suspicion, right? We talked about that for the stop, were very boilerplate, meaning they kind of all looked alike with no specific real legal reason for the stop, right? You can't stop someone on a hunch. That's not reasonable suspicion. The stops were also found, for the most part, to be unproductive, since very seldom did the stop lead to the recovery of a weapon or an arrest. And on the other hand, law enforcement at that time would say, well, but it's a deterrent factor, people knowing that they might get stopped. So again, do you see the dilemma here? And while stop and frisk is a great tool, it needs to be used within the confines of the law and the case law that actually allows it. So hopefully that kind of makes sense. So let's talk just a little bit more. So when we talk about race and reasonable suspicion, a stop may not be based solely on race, ethnicity, or religion. These characteristics alone may constitute one factor that, along with other factors, constitute reasonable suspicion. So you can't just stop on race, right? Or religion, but that can be one factor of others. So let's say that you're driving as a patrol officer late at night and you're driving down a residential street and you see somebody walking, they see your police car and they duck down behind a car. That is kind of suspicious, and that would be enough reason to actually stop and ask the person, hey, what are you doing? But not just on their race. And then again, that scope and duration of that Terry stop that I mentioned, these stops under Terry versus Ohio, they're limited in the in the permissible movement of a person and the duration. So it can be only for a very short period of time, right? You can't like stop someone and just hold on to them for a long time. Okay, so let's kind of keep going. Well, you know what? This might be a good time to kind of finish up, and we'll take our break. So evidence indicates that racial profiling, either through traffic stops or investigative stops, doesn't occur necessarily because officers are racist. It is an entrenched part of policing because there is a suspicion of black men held by white and black police officers, combined with the pressure to conduct investigative stops to obtain drugs and other contraband. And this pattern of enforcement may lead to a script of resistance and disrespect, right, on the part of those people stopped, which in turn incites some officers to kind of ratchet up the force, if you will, used, so that a simple stop ends up being a resisting arrest charge or even worse. So, kind of just understand that, there really are two sides to this coin. And you can see, I hope, how complex a lot of these issues actually are. So with that being said, this will be a good time for us to take our first break. So this will conclude part 1 of chapter 6, Police Discretion and Dilemmas.